Good morning. Welcome to the First District Court of Appeals. We have two cases scheduled for argument today. The first case that we have is case number C200353, Great American Insurance Company of New York versus Philadelphia Indemnity Insurance Company. If please identify themselves and their readiness to proceed.
Good morning, Your Honor. On behalf of the appellant, Richard M. Garner, and we are ready to proceed.
Thank you.
And on behalf of the appellee, Great American Insurance, this is David Walulik. We are ready to proceed.
Okay, thank you, counsel. Attorney Garner, would you like to reserve time?
5 minutes, please, Your Honor.
All right, thank you.
Thank you. This is a dispute between two insurance companies about defense costs. The underlying actions were in California. The parties were in California. The lawsuits involved circumstances in California. Those lawsuits have been fully resolved. There are no parties involved in this. There's no conflict between insureds and insurers in this case. It's solely between the two insurers. The trial court, Judge Callan, entered judgment against Philadelphia in the amount of $153,855.32 on Great American's sole claim of equitable contribution for defense costs. We're asking this court to reverse that judgment based upon two assignments of error. The first is that equitable contribution was not permissible because the Philadelphia policy was neither triggered nor attached nor provided the same kind of coverage as the Great American policy. And the second assignment of error has to do with the fact that if this court finds there's contribution, that contribution should have been limited to $26,000 and change, which we have set forth. And it's a contingent.
Counsel, the Philadelphia policy was for the civil rights violations, isn't that right?
Correct.
And that was one of the claims.
Correct.
So by it being a claim, isn't it triggered at that point?
No, and that's the reason why when we look at the features of this policy, really when we look at the first assignment of error, which is where I'm going to spend all my time unless the court has questions about the second assignment of error, which is contingent, we really see two factors that determine this, Judge Zayas. The first is the plain language of the Philadelphia policy, which is very different than the Great American policy. So it's not the normal duty to defend. It's a director's and officer's liability policy. And the second could possibly be choice of law, which we'll deal with. But again, as I've argued in our brief, we don't think choice of law is going to change the outcome of this case. Either way, you're going to end up with the finding. So let me take you through that, Judge Zayas, because there's 7 features I want to look at for the Philadelphia policy. And before we begin there, I think it's important to understand that we're not going to talk a lot about the Great American CGL policy. And the reason why is because it's undisputed that they had a primary duty to defend, that they did in fact defend. They defended all the defendants and all the claims, and that's what they were required to do, whether it's under California law or under Ohio law. But when we look at the Philadelphia policy, the first 2 features I'm going to go by quickly. That is that it's a director's and officer's liability policy for civil rights as opposed to bodily injury. And secondly, that it's a claims made policy. Put those two together, that's a very different kind of policy than CGL. But when we get into the substantive terms for defense costs, this is where it really becomes interesting. The third feature I want the court to look at is that we're a reimbursement policy. When you look at something like the Great American policy, they're required to provide a defense, hire counsel, and make sure that that's being taken care of, control the defense. But our policy, defense costs are a part of loss. That is, they erode the limits of the policy rather than being supplemental. Like the CGL policy, the Great American issue. And defense isn't required by us. We simply reimburse. When I say us, I want to make sure we get the pronouns right these days. We're talking about the Philadelphia policy. Defense is not required under the Philadelphia policy. It's simply reimbursed. The insured decides who they want to defend them and how they want to do this, unless it's being controlled by someone else, as in this case, the Great American. The fourth feature is that defense costs are not for all claims, which is what it is for a CGL policy like the Great American policy, but only for indemnified claims. And remember, we only had 2 insureds here. We had Satellite Affordable Housing Associates in Jefferson Oaks.
When you're talking about defense costs and not for all claims, I'm looking at the definition of defense costs under the common policy definitions.
Right.
That part of where your discussion is coming from?
Right.
Okay, because there, if you go to little section A, and I think this is where you're going, it says any amounts incurred in defense of any claim for which any other insurer has a duty to defend, regardless of whether or not such other insurer undertakes such duty.
Correct. And that's the next feature I was going to go to directly, Judge Zayas, is the way this policy sets up. It's a reimbursement policy for defense costs. Defense costs come out of limits. And therefore, when we look at that, we have this provision in our policy, which is the fifth feature, which is that defense costs do not include any amounts incurred in defense of any claim for which any other insurer has a duty to defend. Now, I want you to think about that for a second, because I want you to think
Clearly, I
about
thought about it.
Yeah, well, the reason why I'm saying is because it's an incredibly great benefit to the insured. Why? Because if we look at Great American's policy, their defense costs are outside of limits. That is, they could spend $1 million on defense costs and it will not erode the limits. Whereas under the Philadelphia policy, every dollar spent on defense is one less dollar you can spend on indemnity. So one of the features of the Philadelphia policy to protect the insured and give the insured greater protection is that if there's anybody else that's required to defend, the Philadelphia policy does not defend, and then that inures to the benefit of the insured. The only one that wins by making this argument that's being made here today is an insurance company, Great American, that's trying to limit the amount that it has to pay in defense costs by transferring that liability to somebody else. And so in this particular case, the express provisions of the Philadelphia,
Are they not?
I'm sorry?
They're looking to share that liability, are they not?
Well, they're only looking to share it if we had it in the first place. And so they're saying, when we look at equitable contribution, it looks like this. We say, okay, one insurer is discharging an obligation that's owed by multiple insurers. And therefore, it has an equitable right to go back against the other insurers that share the same obligation. The problem that they have in this case is that we don't share the same obligation because we're not even triggered or attached until such time as they're exhausted and if they're defending. It takes us right to the sixth feature, Judge Zayas, which is not only do we have this provision that says if anyone else has to defend, we don't defend, but we also have the...
I understand what you're saying, you're not triggered. Or you're saying you're not triggered for defense costs? Or are you
Correct.
saying that you're not triggered for, let's say that there was a damages award that went to the civil rights violation, would you not be triggered for that portion of it?
Now, this is critical and why we talked about this and the differences between the policies. For a CGL policy, like the Great American policy, normally the duty to defend is broader than the duty to indemnify. And if you have a duty to defend, you can have a duty to defend, but the duty to indemnify won't necessarily be triggered or could be triggered or not be. In our case, we could have a duty to indemnify, and we did. We, in fact, settled part of these claims, but we never had a duty to defend on this reimbursement.
So when you're saying
policy.
triggered, you're limiting that to the duty to defend.
Correct. The duty to indemnify is not at issue in this case at all.
Okay.
And because these cases are settled, Judge Zayas, so one other thing I want to say, if this had been fully litigated, it's possible that there wouldn't have been any indemnity either. But the parties took that, they resolved that. They decided to resolve this, and Philadelphia stepped in and paid part of the indemnity here. So the next thing that we want to look at, the next feature that ties on to what we were just talking about, is that the reimbursement of defense costs under the Philadelphia policy is excess of two things. Number one is a $50,000 uninsured self-insured retention, SIR, which means they cannot have insurance for it. The Great American policy cannot satisfy that $50,000 SIR, plus any other insurance which is valid and collectible, which would include the Great American policy. So under the circumstances that we have here, there should have been no possibility for there to have been defense under the Philadelphia policy because Great American was defending. Now, one of the things that they've argued, and they've said this over and over again, is that the Great American policy expressly, strike that, the Philadelphia policy expressly says that Philadelphia will pay 100% of covered and uncovered claims, but they leave out the most important provision of that section. If you look at page 12 of our brief, we actually have the section there that they keep citing over and over again without the important language. And that 100% provision applies solely with respect to claims for which the insured has tendered control of the defense to Philadelphia. And that never happened in this case because the defense was always controlled by Great American.
Well, Philadelphia acquiesced to the defense, right?
No, we didn't. What we said is we would participate, Judge Krause. And if you look at our reservation of rights that we issued to the insured in June 9th of 2017, actually it's June 14th of 2017. We expressly told them that because the Great American policy was defending that we may not owe a duty to defend here at all. However, we needed to go through the process and see what was going on. Remember, we didn't get involved in this case until 13 or 14 months after Great American started defending, and we knew virtually nothing about this case when we were asked to participate in the mediation. So we said, send us this information so we can evaluate how we should participate. And we said we certainly would participate in this. After the parties went to that mediation, they agreed to settle some of the cases, some of the claims, and they did so under that 2018 funding agreement, which is attached to our index of the trial record, Bates number 6 to 13. And in that 2018 funding agreement, Great American specifically agreed that any defense that was owed by Philadelphia was subject to the reservation of rights that we had issued, which is Bates numbers 107 to 111. And under those circumstances, we told Great American and we told our two insureds, because Great American is defending, we might not have a duty to defend at all. In fact, Mr. Waluik himself specifically and expressly responded to those letters at pages 115 to 119. And then there was a response back from Philadelphia's California counsel that explained why we thought that there may not be any defense of it. That said,
But that all goes to the other insurance clause, right?
some of it does, but Judge Zayas asked about the provision that actually defined defense costs, which is defense cost does not include any amount that's owed by another insurer. And in this particular case, it's unquestionable that Great American owed 100% duty to defend all claims, all insureds here. We're an excess carrier. We're not even in a situation where there should have been equitable contribution possible. This is a situation where we don't provide the defense. We expressly carve it out of defense if they owe it. Moreover, we put ourselves in an excess position where excess insurers do not owe a duty to defend unless and until the primary insurance has exhausted, which didn't happen here.
And
So
the term claim is defined very broadly in the Philadelphia policy, right?
correct.
I think initially when I read it, I thought, oh, well, you all cover civil rights claims. They cover the other claims. So it's not really, there's not another insurer defending a claim that you're responsible for until I looked at the definition of claim in your policy.
Well, and I think Judge Krause, I would take that back. I'd say we wouldn't talk a lot about the Great American policy, but I think we need to go back and look at the Great American policy and understand that a CGL insurer like Great American, when they have an obligation to defend one claim, they have an obligation to defend all claims, even if they're not covered claims, even if they won't ultimately owe a duty to indemnify under that. And that's just standard across the board in almost every state of the union that has to happen for CGL insurance. D&O coverage does not operate that way. D&O coverage normally says we only defend and allocate to those claims that are actually indemnified for. And in this particular case, the reason why Mr. Waluik was able to avoid that conclusion, Great American was able to avoid that, is because they omitted the important policy language from the Philadelphia policy that said, we'll pay 100% even for uncovered claims, but only when we're controlling the defense, which never happened here. And that's undisputed under the circumstances. So there's really just five features. Go ahead.
You have just seconds left.
Okay. Well, I think we've talked about most of what we want to talk about. So I'll reserve the rest of my time. Judge Zayas, thank you very much.
Thank you.
May it please the court, this is David Walulik on behalf of Great American. I'll dive right into some distinctions and picking up on some questions that the court asked. For purposes of the duty to defend, we've quoted the Philadelphia provision accurately on page 20 of our brief. Philadelphia has a duty to pay 100% of reasonable and necessary defense costs for both covered and non-covered claims and covered and non-covered parties. What happened here was you had three underlying lawsuits, which alleged claims that were covered. Civil rights violations under the Philadelphia policy are covered under the employment practices coverage. Bodily injury claims were potentially covered under the Great American and First Mercury. Keep in mind, we had a third insurer here who was settled out and paid its pro rata defense. So you had both insurers having an obligation to defend the entire lawsuit, because whether this is under California or Ohio law, if an insurer has a duty to defend one claim, they have a duty to defend all the claims in the lawsuit. There's
But
no.
wouldn't that, I mean, are you saying that the case law would trump the language in the policy, or that it could trump the language in the policy?
I'm saying that the language is consistent with the policy. What Philadelphia has a duty to defend is pay 100% of defense costs, whether they're covered or uncovered claims.
So what would you do with the definition of defense costs as defined in the definitional section of the Philadelphia policy?
Well, the definitional section is amended by section 19 of the policy, 19.1 that we quote on page 20 of our brief. So if there's a claim that is triggered under the Philadelphia policy, which there clearly was an employment practices claim for civil rights violations, what the Philadelphia policy provides in its allocation section is that even if there are uncovered claims, Philadelphia still has a duty to pay 100% of the defense costs. And if you contrast that with the section that's right below it, which we also quote, Philadelphia can allocate indemnity at the end of the day, which is what was done. Indemnity is not an issue here. They cannot allocate between defense. Once that defense obligation is triggered under the Philadelphia policy, they have to pay 100% of the defense, whether they're covered or uncovered claims, or even covered or uncovered parties. In this instance, the plaintiff sued the property manager. They sued a variety of people, but there was one defense. And then going back to Justice Krause's question, Philadelphia did acquiesce and agreed to the defense. In fact, they agreed in a June 9th, 2017 letter that they had an obligation to defend. The court can read that in the trial docket. Their coverage counsel agreed in August, Mr. Bloom, in a letter that's cited on page 10 of our brief, that they agree that this counsel should remain in the case. So there's no issue as to whether they were tendered or not. They clearly were tendered. They provided a letter back acknowledging that they had this defense.
How do you get around the other insurance provisions in their contract?
There are two other insurance provisions. One relates to defense and one relates to indemnity. Philadelphia argued several times about an excess provision. Philadelphia is not excess to Great American. They do cover different types of risks. The defense provision is what's called an escape clause. What
Right.
Philadelphia is contending that if two insurers have a duty to defend or pay defense costs, then Philadelphia pays nothing. They escape the liability. Now, under a choice of law analysis, which was really what was the critical thing here, Ohio and California don't conflict on that. Number one, there's no binding Ohio precedent enforcing the escape clause. And Philadelphia has not cited a precedent throughout any of its briefs under Ohio law, saying that somebody with an escape clause can simply walk away when another insurer is up to the plate and has a duty to defend. California has a California Supreme Court case directly on point, DART, which we cite. California will not enforce this clause.
Does Ohio enforce them?
There's no definitive precedent in Ohio. So there was no conflict of law here. The court just simply held that they would have an obligation equitably to do this.
But the clause is there, and I'm asking, how do we get around this clause?
Well, we get around the clause is there. We get around this clause by noting that Philadelphia and Great American are covering different types of claims in this underlying case. What if Great American simply would have said, well, we don't cover all these claims either. So, there are claims here that Philadelphia clearly was triggered to defend. And that clause would not apply because they're covering different risks within the same lawsuit. The defense is indivisible. Once one claim triggers, all the claims are triggered. The problem here is you have one state that just simply won't enforce the escape clause and another one with no definitive precedent on it. So both insurers, as an equitable matter, which contribution is an equitable matter, should share that defense.
The language says this policy shall be excess over any other policy under which another insurer has a duty to defend a claim. So it clearly is stating the policy is excess. Great American had a duty to defend a claim, right?
The policy is a primary policy with an SIR. It's excess over a self-insured retention, which there's no dispute that was paid. And then the issue becomes, now that the self-insured retention was paid, how does Philadelphia claim that it still has no obligation to step up and do anything here? It's not like this was written with Great American being a primary insurer and Philadelphia coming in at a layer of excess above it. These insurers are both primary insurers. They're just covering different types of risks.
Well, what about the fact that the premiums are dramatically different between the two policies? And I know that's something that Philadelphia raises, the dramatic price differential between the two is something that we can look at to determine if it's primary or secondary.
Well, I would just submit to you that the price differential is different because they cover different types of risk. Philadelphia is a policy that provides for D&O coverage. Great American provides for any type of bodily injury coverage. Philadelphia actually excludes bodily injury. There are cases in both Ohio and California where Great American doesn't cover civil rights. If the policies are priced differently, it's because they're covering different types of things. It's like saying that you have an auto policy and a homeowner's policy. Well, they're covering different things. The problem here is we have one lawsuit that triggered both policies from the standpoint of third-party liability. So if they're priced differently, that's correct. Another reason why the Philadelphia policy is priced differently is it sits above a self-insured retention, which nobody disputes was paid. So you get a lower premium if you're covering the first, several $1,000s of the loss. In this case, I can't remember if it was 25 or 50. I apologize to the court for not knowing that off the top of my head. But that's why you pay a different premium, because all those claims would be within the policyholder's risk below that. Going back,
Philadelphia's argument seems to be that for the purposes of what they characterize as indemnity, I guess what I would call liability, that they are a primary, but for the purposes of defense costs, that they're either in excess or that they're actually not even on the hook because of the language of how defense cost is defined.
well, I would submit that the language of defense costs is very clear as to how it's defined. They're clearly on the hook for it. If there's a claim within the underlying case that triggers the Philadelphia policy,
My point is this, that I think that they might possibly agree with you with regard to indemnity, but the issue before us is defense costs of how does this policy apply for the defense costs?
well, we quote the policy on page 20 of our brief as to how it would apply on defense costs. And what it provides is that if there are both covered and uncovered matters or covered and uncovered parties, then coverage shall apply as follows. Number one, defense costs, 100% of the reasonable and necessary defense costs. That's what Philadelphia pays, whether they're covered or uncovered claims or covered or uncovered parties. Philadelphia pays 100% of the defense. Now, for loss indemnity, Philadelphia may allocate under the express terms of its policies that we quote on page 20. They may not allocate.
So what do we do with the language that says, well, they're not on the hook if there's any other insurer that has a duty to defend? And by the language of the Great American policy, there is a duty to defend.
Yeah, but Great American, you have to go back to the definition of claim. Great American doesn't have the same duty to defend claims that Philadelphia does because we don't cover the civil rights violations.
Isn't your duty to defend triggered when there's any claim and then there's a duty to defend on all claims?
Well, both insurers are triggered if there's a duty to defend one or all claims. I mean, the irony here is that Philadelphia is arguing for California law to apply here. And if California law were to apply here, it's quite clear that California won't enforce this escape clause. Now, alternatively, does Ohio enforce the escape clause? There's no definitive precedent, and it's Philadelphia's burden to prove that. So, under either scenario, this is
one thing that neither party raised, and maybe I'm missing the boat. Isn't California a horizontal exhaustion state and Ohio is a vertical? So it seems to me that also plays into the discussion of excess and things of that nature and what's triggered.
We didn't brief the issue of all sums allocation, but both states are vertical. And both states.
California is also vertical, they're not horizontal.
Yeah, both states would require any trigger policy to essentially step up to the plate and exhaust. If we're talking about a horizontal exhaustion, Your Honor, there's no dispute.
California's not pro rata?
No, California is an all sums jurisdiction.
Okay.
Now, as far as whether the primary layer below Philadelphia, there is no primary layer. They're an SIR insurer, and that SIR was paid. There's absolutely no dispute about that. So, going back, I would just take a look at, what type of equitable precedent does the court want to encourage here? We've got one insurer who footed 100% of the defense costs throughout this, when we had three insurers who were conceivably triggered by this. I mean, there's no dispute that there was a trigger. This is an equitable cause of action where, Great American is not a party to the Philadelphia contract. We're not bound by the contractual terms of the Philadelphia policy. What we do have is an equitable.
So let me ask you this. Let's say that Philadelphia didn't exist and there was no insurance policy for the civil rights portion of the cause of action. Um, wouldn't Great American have a duty to defend all claims?
Right, and the converse would
Okay.
be true as well. If
And
Great
then,
American did not
because my follow-up question to that is, would Great American go after the insured for a portion of the defense costs? Since there was no insurance policy governing the civil rights portion.
we would certainly reserve our rights on that. That didn't happen here, but that's a valid reservation to the extent that there are claims that aren't covered. An insurer typically will defend under reservation of rights and allow itself a right to recoup if necessary if the claims are not covered.
And what would Great American rely on in order to seek contribution from the insured?
Well, there wouldn't be contribution from the insured. It would just be an allocation, and it would be the contract. Now, there's no dispute that the insurers, the policyholders, are governed by their contract with each insurer.
I'm talking about just for defense costs. I'm not going beyond defense costs in my hypothetical.
Well, the hypothetical just never transpired. I'm not sure. We haven't briefed the issue, and we don't have the case law on that. But I would just simply say that there would be a reservation of rights, and it would be based on the contract that the policyholder had with the insurer. We're one step removed from that, in that we have two insurers with no contractual privity with each other, one of whom has sued the other one in equity. And then so the issue becomes, what type of equitable contribution claim would be allowed here? We're not bound by the Philadelphia contract. What we do know is that Philadelphia did have a duty to pay 100% of the defense costs. We're the ones who paid 100% of that defense costs under our own contract, which allows us to have an equitable contribution claim back against the carrier who did nothing, essentially.
Are you asking us to find that the escape clauses in their policy are unenforceable as a matter of public policy?
It would be unenforceable as a matter of California public policy, for sure. There's no Ohio precedent on the issue.
Are you asking us to somehow make that finding?
Well, without a conflict, I think the court would enforce whatever state law would be applicable there. So California could apply here, and we could have a non-enforcement of the escape clause. But if the court wants to consider this under Ohio law, certainly there's no precedent for this. The escape clause would operate vis-a-vis the policyholder and the insurer. There's contractual privity between Philadelphia and its policyholders. There's not contractual privity with Great American in Philadelphia. We're operating completely in an equitable sphere here, where we're not bound by their contract. All we have to prove to establish contribution is that Philadelphia did have some type of duty to defend these claims. And they did have a duty to pay 100% of defense toward both covered and uncovered claims.
Let me ask you, and this is directed, I know your time's almost up, sir, so it's directed at both of you. Now, sir, you're describing the Philadelphia policy as an escape clause. I'm looking at the, looks like the Second District Court of Appeals in Meridian versus Auto Owners described three separate clauses. One is an escape clause where the insurer would not be liable at all. One is an excess clause, and the other is a pro rata clause. So the question is, what is the difference then between an escape clause and an excess clause, or are you saying they're the same thing?
I'm saying that vis-a-vis the policyholder and the insurer, when there's a dispute as to whether there is coverage, there can be an allocation under that provision. That's a contractual term that can be enforced between the parties to the contract. What I'm saying is that we're not a party to the Philadelphia contract. And there's no dispute that the Philadelphia contract was triggered by the underlying claims in this case. And there's also no dispute that Philadelphia owed the policyholders in this case 100% of defense, whether there are covered and uncovered claims or covered and uncovered parties. So Philadelphia was triggered. Philadelphia had a duty to pay those defense costs. That's all Great American needs to establish for purposes of a contribution claim, that there were two insurers who both owed an obligation to a policyholder to defend. Great American did that, and we stepped up and defended the whole thing at our own cost while the other two insurers did nothing. Ultimately, we were forced to file suit here. As soon as we did, one of the other carriers agreed to pay its pro rata defense. The trial court agreed that Philadelphia owed its pro rata defense, and that's what we're seeking to affirm here, that Philadelphia just needs to share its pro rata defense as it did with the indemnity.
Let me ask you, sir, when Philadelphia wrote that policy, let's just assume they believe they were an excess insurer. Isn't that something that goes into their consideration when setting the policy? In other words, if say you're insuring me, sir, and I know that you have I don't have any responsibility until such time as you've paid $1 million, and then that's when mine kicks in. Wouldn't I take that into consideration when setting the cost of my excess policy?
You certainly can. This was Philadelphia had issued an SIR policy, and there's no dispute that the SIR was paid.
Right.
So, there's no dispute that condition precedent has been satisfied.
All right. So, but you're saying Philadelphia cannot consider the fact that you may have a policy that is sufficient. Let's just leave it at that. Do you understand the question?
Yeah, I understand. Philadelphia can certainly consider that there's other coverage out there. What I'm submitting is that there were different risks that are covered by the underlying claims. The policy holder and the insureds, all these insurers split it pro rata for indemnity. We're just simply arguing that it should be split pro rata from an equitable standpoint for defense as well, because both insurers had their defense obligations triggered.
Okay, thank you.
Would you like to wrap up, counsel?
I'm finished unless the court has further questions.
Thank you. Judges, this is important, and you may not have the briefs right in front of you, but this is critical to this entire case based upon what has been argued to you. Mr. Walulik said, go to page 20 of his brief, and Philadelphia policy language is cited, which says 100% defense and indemnity. And if you go to page 20 of his brief, they actually have a portion of the Philadelphia policy cited there that says that. But here's the problem. You go to page 12 of our brief, and you have the same policy language with the important condition precedent there. Solely with respect to claims for which the insured has tendered control of the defense to the underwriters, Philadelphia. That's when the 100% kicks in. That never happened. It's undisputed. It never happened. If that doesn't happen, then the actual provision that governs what Philadelphia owes for loss, and remember, that's why we talked about it being a reimbursement policy where defense cost was a part of loss, and that's what Judge Zayas and I were talking about, defense costs being a part of loss. Then the allocation provisions we have cited on page 11 of our brief kick in. And this is what they say.
They are disputing whether it was tendered. I mean, their argument is that you all acquiesced to the defense in this case. You got involved and you said, okay, we're good with the way this defense is going.
But
so
it wasn't
can't that be considered tendered?
Yeah, the control of the defense, because the way the policy is set up is that the insured gets to choose who their lawyer is. And if it's tendered to us, we get to choose who the lawyer is.
But you agreed with who the lawyer was.
I'm sorry?
Philadelphia was fine with who the lawyer was.
Louis Brisbaugh was already defending for 13 months before we even got involved. And so we didn't ask for there to be a change there. We asked for additional information. We reserved rights and said, because Great American is defending, we may not owe anything based upon the provisions of the policy. But it is absolutely incorrect and untrue that we agreed to tender or that we agreed to pay 100%. In fact, at all points in times, we relied upon all provisions of our policy. And Great American actually signed the 2018 funding agreement. They're in privity of contract with us, saying that, in fact, they understand that we're handling defense costs under full reservation of rights. And they had a copy of our reservation of rights saying this. What he's saying is that equity should be able to trump the policy, that he shouldn't have to pay attention to what the policy says, that he shouldn't have to make any arguments with respect to whether there's limitations in the Philadelphia policy, and he should be able to just unilaterally declare that Philadelphia owes a duty to defend, when in fact, that was an open dispute from the moment we got the case, because we knew Great American had it. So we said
if we were to believe that somehow it was tendered to you and you acquiesced, do you still get out of the defense under the policy language based on the excess clause? Or
yes, there would be two provisions that would actually there'd be three provisions that would be there.
So and even if we disagreed with you on the tender issue,
right,
I mean, you still somehow get out of the defense?
We would still have, well, when you say get out of the defense, we never then agreed to defend under the circumstances of this case. So I want to make sure we're being clear. There is no sleight of hand by Philadelphia here. This is a policy that was written before the loss.
Right.
So the provision that says defense cost does not include any amounts incurred in defense of any claim for which another insurer has a duty to defend that would prevent Philadelphia from owing any defense costs here. Plus, going to Judge Winkler's question, we have an excess. So, and let me stop there for a second. Judge Winkler, I think that provision probably under California law might be characterized as an escape clause. But under Ohio law, it's perfectly enforceable because there's nothing that says that it's not enforceable under Ohio law, and we enforce contract language. But in addition to an escape clause, we have an excess clause because we don't have just excess of the $50,000 uninsured self-insured retention. We also have excess of any other applicable insurance, and it's unquestionable that Great American was other applicable insurance, and we are excess of them. In fact, that's the whole point of their argument. Listen to what Mr. Wolulik also argued to you, because it goes to another fundamental problem that he has here. He says, well, look, the excess other insurance clause doesn't apply because these are two different kinds of insurance. Well, that should be the end of the story then, because there can't be equitable contribution when there's two different kinds of insurance under either California law or Ohio law. One of the things that's important when we look at this, first of all, I don't think the all sums, Park, Ohio is my case. Pennsylvania versus General Insurance Company versus Park, Ohio Industries. I argue that in front of the Supreme Court and won it. This is an all sums case. The Park, Ohio case was an all sums case dealing with long tail occurrence between multiple CGL type carriers. It did not involve D&O coverage. And even in that case, it specifically said the policy had to be triggered in order for the policy contribution to be sought. That's exactly what we're talking about here when we say we're neither triggered nor are we attached, nor is it the same kind of risk that's being involved. And you actually heard Mr. Wolulik make that argument himself. We're not the same kind of risk, and therefore we're not in privy to contract. This is pure equity. What he's saying is that he has no right of contribution here because he didn't discharge an obligation that we had, because we had no obligation to do what our policy says we didn't have to do, which was to provide defense costs here. And remember, the reason why this policy is structured that way, Judge Krause, is not to give us a benefit, is to give the insured a benefit, because defense costs erode the limits of this policy. Let's say they get hit for a civil rights case. Instead of settling, we go down the track and we find that only the civil rights violations here happen here. But the case goes on for years, and we spend $1 million defending this case. We're done. We don't owe any indemnity because we paid all of our limits in defense costs. The only one that benefits from that is Mr. Wolulik's client, Great American, because they've got an obligation to defend every claim and every defendant all the time. And it's supplementary. It doesn't erode their limits. And so they benefit, the insured loses, and Philadelphia loses. That's what he's asking you to do under the circumstances.
Thank you for your arguments this morning.
Thank you very much.
Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision. And we wish you a wonderful afternoon.
And to you. Thank you.
Thank you.
Good morning.
Morning, Your Honors. Brian Perkins on behalf of Appellant.
Good morning, Attorney Perkins. So we are now here on the second case and the last case that's set for argument today, which is case number C190752 and 753, State of Ohio versus Scott Svoboda. Did I pronounce that?
You did, Svoboda, yes.
Okay, thank you very much. So Attorney Perkins, you are here on behalf of the appellant.
That's correct.
Okay, and you are ready to proceed?
I am ready to proceed. I would like to reserve 5 minutes rebuttal if I could.
Okay, and I just want to introduce Attorney Brandt. Did I pronounce that correctly?
Yes, Your Honor. Kirsten Brandt on behalf of the state of Ohio. I am a special prosecutor assigned or appointed by the Warren County Prosecutor's Office, but I am representing the state.
Thank you. Thank you for being here this morning. Attorney Perkins, you were saying that you wanted to reserve 5 minutes.
Yes, Your Honor.
Okay, whenever you're ready.
Your Honor, Your Honors, the one thing I want to talk about, probably the majority of my argument, if not entirely, is the first assignment of error. The Sixth Amendment, as well as the fundamental fairness and due process rights, certainly give a criminal defendant the right to be free from governmental intrusion into the attorney-client relationship between him or her and his defense attorney. This case is a case of first impression for this court. The facts of it are very unusual. And I think to come to the proper remedy in this case, this court needs to look at the case law from the whole country, federal and state, because there's just not a case exactly on point in the state of Ohio.
Before you start, I just want to clarify a couple things, okay?
Yes.
Is the issue here with regard to the transcript, the CD, or both? What
The
was
issue-
it? I didn't even frame the question. Hold on. The state believed that there was some disclosure that should not have taken place.
Correct.
Is that with
Correct.
regard to the CD, the transcript, or both?
I believe it was as to the report, the transcript of the interview at Mayerson Center.
Okay.
Because I don't believe there could be an argument that Mr. Svoboda had the actual CD in his cell, because prisoners aren't permitted to have CDs in their cell. So
Okay.
the issue would have been the prosecutor believed that the Mr. Svoboda had in his cell a transcript of the interview that was done at the Mayerson Center involving the juvenile alleged victim.
Okay.
And that came about, oh, I'm sorry.
So with regard to that transcript, there was a hearing on April 15 and 16, and it seemed as if both parties in that hearing referred to the transcript and seemed to be saying that the transcript was not marked counsel only.
I think it was.
Is that what the record? What does the record reflect with regard to that transcript? Was it marked or not marked counsel only?
That we don't know. Now, the prosecutor claimed it was marked for counsel only. I think there was a question from defense as to whether it was or not, but it was never admitted into evidence. So we can't say for sure whether or not it was marked for counsel only. That seemed to be an issue that was never resolved.
Okay, thank you.
But whether it was or was not marked for counsel only, Rule 16 only prohibits giving over that discovery to the defendant or actually showing it to the defendant, but it does not prohibit telling the defendant about what's in that discovery, right?
That's correct, Your Honor. Again, even if it was marked for counsel only, just because the prosecutor went in eavesdropping on a telephone call from Mr. Svoboda heard that he had knowledge of the content of what was contained in that report or that transcript would not be a reasonable basis to believe that he actually possessed that transcript. Because again, criminal rule 16G, I think it is, allows the defense attorney to sit down with counsel, can't give him a copy of it, can't turn that over to him, but can certainly read it to them or explain what is in the report. So again, and I think that that's an important factor, because when you look at all these cases, one of the things they look at is as to whether or not to apply the prejudice per se analysis, which I am asking the court to apply prejudice per se in this case. But if you look at the cases, what they look at is was there a legitimate reason for this interference? And I think certainly there are cases that perhaps there is a legitimate interference to take clients' legal paperwork. They also look as to whether the violation was purposeful. They also look as to whether or not trial strategy was violated. All those three factors, if those are present, pretty much it's a unanimous of all jurisdictions that if those are present, that they will find it to be prejudice per se, requiring reversal of those convictions. And in this case, again, no legitimate reason to have taken his legal paperwork. Even if he had this paperwork, which he didn't, but even if he had it, that's not a legal basis. That's not a sufficient justification to go and basically pillage all of his legal paperwork directly by the prosecutor.
So what should we do with the fact that it's not clear whether it's marked or not marked for counsel only?
I would submit to the court, it doesn't matter. It doesn't matter. I mean, even if it was marked counsel only, it's still not a sufficient basis. So if you,
And are you saying it doesn't matter because of the language of Criminal Rule 16C or for another reason?
for that reason, because what happened in this case and the facts of this case would not justify the prosecutor to believe that he had this report that was marked for counsel only. If it's not marked for counsel only, that's easy. They definitely had no reason. But even if it is marked for counsel only, that's not a sufficient basis. There was one of the cases I cited, I don't know if it was Caldwell.
So was there anything, I guess, was there anything that was presented in the hearings that went to actually having the transcript at hand versus knowing the contents of the transcript? Was there anything
No.
that went specifically to actually having the transcript at hand with regard to your client?
No, because there was not a hearing on that specific issue. The defense attorney adamantly stated, I never gave this transcript to my client. The transcript was never recovered from Mr. Svoboda's jail cell. So I think that the court was operating under a belief that he never had this transcript in the first place. I would submit that the prosecutor simply used that as a basis to try to justify going through the legal paperwork. But again, going back to your original question, I don't think it matters whether it was marked or not, because even if the court assumes that it was marked, that's not sufficient. Even there was a case I cited where they suspected that the defendant was involved in a conspiracy to steal files from the U.S. Attorney's Office, and the court in that case determined that that was not a sufficient basis. And it talks about how the high motives and zeal for law enforcement cannot justify spying upon an intrusion in the relationship between a person accused of a crime and his counsel. Conduct of that sort on the part of the government is no doubt extremely rare, but if it does occur, a conviction tainted by it cannot stand. So if stealing government files isn't a sufficient basis to interfere with the relationship, certainly a perceived violation of Criminal Rule 16, which wasn't even violated, but if the court were to determine, well, the prosecution did have a good faith basis of that, that is still not a sufficient basis. I believe
one of the things that we are to consider is whether we would apply what I believe is referred to as the no prejudice rule.
yes.
Okay, so let's just talk about that, even though you're telling us not to go there. Okay, I get that. So with regard to the no prejudice rule, what is the evidence in the record as to what the prosecutor gleaned or didn't glean, or what the prosecutor did in that room for those 17 minutes?
Well, that is difficult to answer because there's an extensive affidavit that was prepared and filed by the prosecutor that took the paperwork. However, it does not touch upon, and it touches upon why the prosecutor did what they did, as far as what they heard, what they believed, and so forth, and justification for it. But the prosecutor that reviewed the paperwork never once indicates on the record what was seen under oath. There was no hearing on it, on what was seen, what was obtained as a result of that. The only thing on the record is that a different prosecutor who wasn't even there at the time makes an unsworn, unsubstantiated claim that, well, the prosecutor just thumbed through it.
But is that a claim or is that argument? In other words, is that evidence or is that argument?
No, that's not evidence. That's not evidence at all. That was just the prosecutor making that argument, because that prosecutor wasn't there. That prosecutor wasn't put under oath for any sort of hearing. So it's not evidence of any nature whatsoever. And that presents.
And what was the evidence for prima facie prejudice put on by the defense?
The defense, what was put on the record was that, well, and at first the defense was kind of in the dark about what happened. And the record isn't exactly clear. There is some confusion to that. But at first, the defense doesn't even know who was responsible. All he knows is that this deputy came in, scooped up all his legal paperwork, and took it away. When he contacts the prosecutor and talks about it, again, it's kind of the record is a little bit fuzzy on that, but he talks about that how he was told that, well, there was a claim that Mr. Svoboda had contraband, but that wasn't accurate. So defense counsel, basically put on the record what was in these notes, that Mr. Svoboda was very active in his defense. He kept notes regarding meetings that he had with his attorney. He had notes in there regarding trial strategy. He had notes in there regarding the witnesses, potential cross-examination, potential weak points for the defense.
Sorry to interrupt you, but a little background noise. I want to get to the heart of the matter, though, because let's say, I mean, we know the prosecutor at some point shuffled through these papers, right?
Yes.
We know that now. Okay.
Yes.
I know the defense attorney was having a hard time getting the video during the trial, but it was preserved for the appeal. So we know the prosecutor went through this legal paperwork.
Yes.
The judge then appointed a special prosecutor from outside the county.
Yes.
This prosecutor showed up and, as an officer of the court on the record, said, I have not been told anything about what was in this paperwork. Nothing. I know nothing.
Yes.
How does that not cure everything in this case? That's what I need to focus on.
Well, I think for a couple of reasons. I think for one, that the special prosecutor's representation was not made under oath. It was simply a representation.
He's an officer of the court, though, right?
I understand. The other issue is that the Deputy Jones that took it was an employee of the Hamilton County Sheriff's Office. Also employed by Hamilton County Sheriff's Office was the lead investigator in the case, Detective Stoll. So I think it's a bit, I think it strains credibility to say, okay, for one, a 20-year veteran of the Hamilton County prosecutor, because he went and worked for Warren County prosecutor, is now all of a sudden independent. Is not, he certainly would have talked to somebody, certainly the lead detective that sat through the entire trial and assisted him with the defense. How he would know if Detective Stoll gave him information that was obtained as a result of this search of paperwork, he wouldn't know where it came from. If Detective Stoll was advised, hey, let's do this, let's do that, let's do this, he would have that prosecutor would have no idea where that information came from. And that's what makes this case so difficult to apply the no prejudice rules, because we simply don't know. You can't, once the government learns about trial strategy, I don't think you could ever go back and figure out how that played into the case. So
the real issue we have is that even though they removed the prosecutor, you're saying they didn't remove the lead detective, who presumably, but we also don't know, may have received some information from the sheriff's deputy that looked through the paperwork first. I mean, is
absolutely,
that okay?
Absolutely. And there's nothing on the record as far as any hearing or anything of that nature where the deputy that actually took the paperwork, who was with the paperwork for the longest, for over a half hour, came in and said, I didn't look at it. I didn't transmit any of this information to Detective Stoll. We don't know that, but they're under the same organization. And I think as a case law, when they talk about this scenario, is that one of the cases I cite saying, well, the prosecutor here recommends that yes, there was this violation, but we recommend that you bring in just an outside prosecutor to deal with this. And that court said, no, we're not gonna do that, because that requires us to engage in kind of guessing what went into this conviction.
The counsel, let me pause you there, unless there's any other questions. I'm going to go ahead and reserve your 5 minutes, okay?
Okay, thank you, Your Honor.
Thank you. Attorney Brandt? Good morning again.
You're muted.
Sorry about that.
That's okay.
First and foremost, this case does not involve a per se prejudice test. The test that governs any claim of intrusion into attorney-client communications is the one set forth in Weatherford v. Bursey, which is a case out of the US Supreme Court. That case specifically rejected the Court of Appeals application of a per se rule and stated that even where there is an intentional intrusion, the defendant does not have a Sixth Amendment violation if the defendant cannot show demonstrable prejudice. The Ohio Supreme Court in State versus OC, a 2014 case involving a search of the defendant's jail cell and seizure of legal paperwork, the Supreme Court also applied that Weatherford test and required the defendant to show prejudice.
Does the state agree that this was an intentional intrusion into the attorney-client relationship? I mean, let's just start there.
No.
Where we figure out what we're going to do.
No, this was not an intentional intrusion into attorney-client privilege. First of all, the sole purpose for the prosecutor going into the cell and having that paperwork was to verify her belief based on statements that she heard from the defendant and his sister, her belief that there was an ethical violation by the defense counsel.
So you think that that's fine if a prosecutor believes the defense counsel violated a criminal rule to search a defendant's legal paperwork, that's perfectly fine way to handle things?
I'm saying that that was the purpose with which the prosecutor sees the paperwork. But Weatherford asks whether there has been an intentional intrusion into the attorney-client communications. The prosecutor did not go into that cell, did not look through that paperwork in order to determine or view or examine attorney-client communications. That was not her.
Doesn't it seem as if the purpose is a little fuzzy here? It's not as clear as you're purporting it to be. First of all, was the transcript marked counsel only or not? Because looking at the hearing on the 16th, the state refers to it and says, I didn't have time to mark it. And so the state is saying that it was not marked counsel only.
So there is a little bit of a question as to whether or not it was actually stamped, because my understanding of reading the transcript is that the transcript came directly from the court reporter to counsel. However, as stated on April 16th, the prosecutor responded to the defendant's demand for discovery and included a notation that the Mayerson interview was included in that discovery, and in bold font, capital letters, and underlined, it said that that Mayerson interview was for counsel only. There was also discussion by the prosecutor at another proceeding in front of the judge where she had stated that they had, her and the court and counsel had discussed this for counsel only requirement. And at that proceeding, the defense counsel stated that he understood his obligations and understood that he was not to turn that over.
But as I said before,
Thank you for that,
why does it even matter? Because the Rule 16 would allow counsel to verbatim read the transcript to his client, right? Rule 16 allows that.
Yeah, Rule 16 allows for defense counsel to convey the contents of that report. However, based on the jail phone calls, defense or the assistant prosecutor believed, based on the defendant's statements, his sister's statements, statements about the victim's demeanor, statements about the victim's specific statements and responses to questions, that this was not just defense counsel reading or conveying information to the defendant. This was the defendant specifically having possession of that transcript, and in fact, his sister having possession of the transcript, and they were making remarks back and forth as to, did you read this part? Did you read that part? So this was more than just the defense conveying information. This was a belief based on the defendant's own statements that the defendant had possession of that transcript in violation of Criminal Rule 16. But
Where
when
in
you,
the
Why not take
record,
it to
where
the
in the
judge?
record is that, I'm sorry, where in the record is that evidence that there was a discussion of, did you read this? Did you read that?
that is the April 16th, 2019 proceedings at pages 37 through 39, where the prosecutor conveys to the judge her, why she believed that the defense actually had a possession of the transcript, as opposed to just, having information from the defense counsel. But I would submit.
Why not take that to the judge? I remember reading that, and I do remember that her specifically stating, they were talking about demeanor, and did you read this and did you read that? Why not go to the judge, though? I mean, why believe that this is legitimate to just go rifle through his legal paperwork?
Well, when you look at the affidavit of the prosecutor, she set forth all the steps that she took. I can't speak for the prosecutor, but what I do know from the affidavit is that she was in the process of looking into whether this was a violation to begin with. She took some very deliberate and careful steps just to make sure, number one, was this a violation? Was this actionable? I think in the course of that, then, she was taking other steps to determine whether or not the defendant actually had possession of that transcript. But I would submit that regardless of the reason why she went in there for investigation of an ethical violation by the defense counsel, the Weatherford test requires this court to look at, first and foremost, whether there was an intentional intrusion or whether her purpose was to look for attorney-client communications. And the record shows without a doubt that her purpose was not to look for attorney-client.
But I think that goes back to my question about what is the actual evidence, because there's a difference between evidence and argument. And then from there, we get to Judge Krause's point, which is, well, isn't it cured by the appointment of the special counsel and the special counsel assertion that I don't know anything?
So in response to your first question, what evidence was presented? If you look at the June 7th, 2019 proceedings, that was where the prosecutor's supervisor came in, and he represented to the court as an officer of the court that Miss Oswald did not go in there with any purpose to look for communications. All she was looking for was a easily identifiable, lengthy written transcript that would be readily apparent just by its outward appearance.
But that's my point. Isn't that argument? Wouldn't
Well,
that have been better placed within her affidavit, and then it would be evidence?
it was not placed within her affidavit. It was a representation to the court by an officer of the court, and I would submit that there was going to be a hearing on this. And perhaps at that hearing, Ms. Oswald would have testified. Perhaps at that hearing, the supervisor would have testified. But the defense withdrew their motion, because they got the remedy that they wanted. The motion was to disqualify the prosecutor. The motion was to disqualify the entire Hamilton County Prosecutor's Office. They got the remedy that they wanted. The court, out of an abundance of caution, removed Ms. Oswald from the case, removed the entire prosecutor's office, and with the agreement of the state, appointed a special prosecutor. And that would bring me to my next point, which is that the appointment of the special prosecutor shows without a doubt that the defendant has not been prejudiced. The defendant was able to receive a fair trial, and he did receive a fair trial.
What do you do with the argument that they're making now that somehow this whole thing is still tainted because the lead detective was with the sheriff's office and his colleague looked through the legal paperwork? Seems like that they're saying it doesn't matter that a special prosecutor was appointed.
Well, all of the defendant's allegations, whether they're allegations that are made here today or allegations made back in June of 2019, are all based on speculation. There is absolutely no evidence that Ms. or Deputy Jones shared with Detective Stoll anything that she saw. There's no indication that Deputy Jones even saw anything that was in the nature of legal or attorney-client communications.
That's hard though for a defendant to prove, right? If the prosecution goes through a defendant's legal paperwork, it's hard for the defendant then to be able to all the time prove that they haven't gotten a hold of some kind of legal strategy, right?
Well, the representations of the court officers, the supervisor of Ms. Oswald, I mean, I think those carry great weight, and I think that
is there ever a place for a per se prejudice rule like the defendant is arguing in this case?
Not in this situation. A per se prejudice rule is limited to situations in which there has been the complete and total deprivation of assistance of counsel. So for instance, in Gideon versus Wainwright, where the defendant was completely denied the assistance of counsel, or the case that the defense cited in their reply brief, Perry versus Leak, where the court prohibited the defendant from speaking to his attorney during a trial recess. Those are situations where there is a complete deprivation of assistance of counsel. In this case, there is not the complete deprivation. The defendant was represented by counsel. Counsel was an aggressive advocate for the defendant both before and during and after trial. So the per se rule does not apply in this situation. The Ohio Supreme Court has applied Weatherford, which requires prejudice. This court has applied Weatherford in State versus George, and the Sixth Circuit, time and time again, has applied Weatherford versus Bursey. And
do you not think that the per se prejudice rule would have applied if a special prosecutor had not been appointed and the same prosecutor had prosecuted the case?
I don't think that a per se prejudice rule would apply, because again, there hasn't been the complete deprivation of assistance of counsel. There is a claim based on speculation that attorney-client communications were viewed, but that claim was refuted by the oral representations of Ms. Oswald's supervisor. In those oral representations, he claimed that Ms. Oswald did not view any legal communications, did not view any trial strategy materials. All she was looking for was that transcript. And she did not examine anything for content. So that's that argument based on speculation that there has been an interference with attorney-client communications has been refuted. In addition, because Ms. Oswald did not view anything of a nature of attorney-client communications or trial strategy, there was never any use of attorney-client communications or trial strategy. There was never any advantage gained by the state. There was never any detriment to the defense. And especially in this situation where Ms. Oswald was removed from the case and a special prosecutor was appointed who represented to the court that he knew nothing about anything regarding the search of the defendant's jail cell. That removes any possible taint. It ensures that the defendant will receive a fair trial. And in fact, the defendant did receive a fair trial in this case.
Do you have any further argument, Attorney Brandt?
Unless this court has any further questions, I would just ask the court to affirm the defendant's convictions and sentence.
Thank you.
Your Honors, if I could just touch on a couple issues. First, I wanted to touch on the Weatherford case. The Weatherford is not the be-all, end-all to answering this question. The Weatherford and the United States Supreme Court left open the question of whether, if that intrusion was purposeful and unjustified, as to whether or not then you could apply a per se rule. That question was never answered by the United States Supreme Court. In fact, the United States Supreme Court, in that decision, it talks about, excuse me, had the prosecutor learned from whether all the details of the conversations about trial preparations, first he would have had a stronger case. In this case, there's no doubt that the prosecutor had access to Mr. Svoboda's trial strategy. And
Not the special prosecutor, right?
Well, again, that's not the special prosecutor, but my position would remain, and what the United States Supreme Court said in Castigar is that the mere assertion by the government of the integrity and good faith of the prosecuting authorities is not enough. So I don't believe that is enough to refute this. In fact, in Schillinger, where the prosecutor had elicited information from a deputy who was in a courtroom when there was trial preparation going on, there was a good faith representation that, oh, well, we don't know any, that doesn't help us. But what the court said in Schillinger says is, what do we know? The deputy prosecutor did not testify under the punitive constraints of disbarment or felony perjury. The deputy sheriff was not brought before the trial court, put under oath, or otherwise examined to obtain a factual recitation of his involvement. So the state has not put on any evidence as to what was seen, what potentially could have been used, what could have been communicated from the deputy to the deputy that was the lead detective on the case, what he may have then transmitted to the, either knowingly or unknowingly, to the special prosecutor in this case. We simply don't know. And in
Mr. Perkins, let me ask you a question then. We'll assume that a third special or second special prosecutor was appointed. It sounds like under your theory, this case can never be prosecuted. Is that where you're going with this? It ought to be dismissed and the state can never prosecute? Because I assume the second special prosecutor will say, I have nothing. I don't know anything about the search of this jail. So, I mean, is that where you're going with this?
Well, I'd say that there would be a lot stronger argument against that if the special prosecutor was not a former Hamilton County prosecutor, if this prosecutor did not sit next to a deputy who was colleagues with a deputy that had been over a half hour alone with Mr. Svoboda's confidential paperwork, that may be a stronger argument. But on the facts of this case, definitely, I would say that this case was wrongfully tried. And if you look, again, I asked the court just to look at the other case law that talks about this. For instance, Briggs versus Goodwin, where they said mere possession by the prosecutor of otherwise confidential knowledge about the defendant's strategy or possession is sufficient in itself to establish detriment to the criminal defendant.
Perkins, let me ask you a question then. What are we to do? The defense attorney, the trial attorney, actually tried the case, seemed satisfied and dismissed its motion. So we're sort of left to speculate. I have no idea what the other deputy may or may not have said. Do you understand what I'm saying?
Right. But I would disagree with the belief that the defense counsel in this case was satisfied. There was what is unusual, there was this entry that was put on July 10th of 2019, which from what I've been able to determine, the defense counsel was out of the country at that time. But there was an entry put on that these motions will not be relitigated. And it was not signed by defense counsel. It was not put on the record. And after that, defense counsel comes back onto the record on page 90 of the transcript, says, I want to be clear about something else. It was not my client's intention nor mine to waive his right to claim that this was improper. So I disagree that defense counsel was satisfied with this. Did he move to have prosecutor removed? Absolutely. But that's not the be all and the end all of what he wanted out of this case. He filed a motion to dismiss. He diligently tried to get the actual video of it because I don't think he was getting straight answers about what happened from the state of Ohio. So he was trying to develop all this potential evidence. He was certainly not satisfied with simply removing the prosecutor from the case. That was one thing he asked for, but not everything that he asked for. And if I can just, the Sixth Circuit is not, does not hold that you have to show prejudice. In fact, if you read the Sixth Circuit case of Clark, which is cited on page 9 of my reply brief, it talks about the Schillinger case, which applies the per se prejudice rule. And it says, and I quote from the Sixth Circuit, it says, the Schillinger case is not inconsistent with the approach adopted by the Sixth Circuit. What it does is it distinguishes Schillinger from most of the cases that the Sixth Circuit dealt with, where it said that what made Schillinger different and what made Schillinger an appropriate to apply that rule of per se prejudice was the fact the intrusion was purposeful and groundless. Both of those apply in this case. So I believe that under that standard, the Sixth Circuit, if it was addressed with this situation, would apply the per se prejudice rule because the intrusion in this case was both purposeful. There's no doubt the prosecutor took it upon herself to remove his legal paperwork, specifically his legal paperwork from his cell and go through it. It was groundless. There was no legal basis or even an arguable basis for her to confiscate all that paperwork and be alone with it for that period of time. And again, I would submit that mere possession of that trial strategy requires reversal of this case.
Thank you. Thank you both for your arguments this morning. We will take the matter under submission, issue you a timely decision, and have a wonderful afternoon.